So good evening, everyone, and a very warm welcome to this high-level panel on the advisory opinion on the obligations of state in respect of climate change, hosted by the UCL Centre for Law and the Environment. My name is Gracia. I'm Professor and Vice Dean International here at the Faculties of Laws, and I'm truly delighted to see so many of you both here in person, we have a full room, I think, and online, joining us with great enthusiasm to discuss this much anticipated climate advisory opinion, I will call it in short term, which was delivered by the International Court of Justice on the 23rd of July, 2025, following a request by the UN General Assembly, which was led by Vanuatu, exemplarily so. In this opinion, spanning over 400 paragraphs, the court clarified the obligations of states for the protection of the climate system from greenhouse gas emission under the entire corpus of international law. So not only the climate treaties, the UNFCCC, the Kyoto Protocol, the Paris Agreement, but also customary international law, other multilateral environmental agreements, such as the Convention on Biological Diversity, on which Elisa will say more, the law of the sea, on which Martins will say more, and international human rights law. Importantly, the law confirmed the legally binding character of this obligation and determine that a breach of such obligations by a state constitutes an internationally wrongful act entailing the international responsibility with legal consequences for that state. So that's a very brief summary, basic summary of the opinion for the benefit of the audience as a whole. These advisory proceedings have been unprecedented, both in terms of the numbers of states and international organizations that have participated, as well as the existential problem of planetary dimensions that was at stake in the legal questions that were addressed to the court. The reactions to these opinions have been, as one could expect, mixed. Many commentators have praised the opinion as historic, groundbreaking, and landmark. Others have, have criticized the court for leaving some of the core issues open, uncertain, or express criticism as to what an advisory opinion, even if far-reaching in principle, can achieve in practice. To enrich this ongoing debate, we have with us tonight a terrific panel of experts who will share their views on the significance of this opinion and what it might mean for international law and our global efforts to address the climate crisis. So I will now introduce the panel and then shut up for a while. I start with our external guest on the panel. To my right, Dr. Justin Sobian? I'm pronouncing this correctly?
Yeah, the French
yes?
very well.
Yes?
Yes,
good.
Thank you.
A lecturer at the Faculty of Law of the University of Auckland in New Zealand, and who notably, among the many things he has done, represented some of the most vulnerable states to the adverse effects of climate change in these advisory proceedings, Grenada and St. Vincent, and the Grenadines before the court. Justin, I don't think we could possibly have a genuine discussion on the court's advisory opinion without a voice from these vulnerable, specially affected countries at the table. And for this reason, I want to thank you for the effort you have made to be here with us tonight.
Thank you.
We have also with us Professor Elisa Morgera, who is a professor of international law and sustainability at Durham University. That's her current institutional affiliation. There were some mistakes in the beginning, but that's her current one. And most relevantly for us, she's the UN Special Rapporteur on the promotion and protection of human rights in the context of climate change. Very significantly as well, Elisa is not only a dear friend of mine, but also a dear friend of UCL, as she completed her LLM studies, like some of you in the room, just a few years ago. And just a few years ago. Time flies. And some of us around the table, without naming anyone, have even taught her international environmental law, I hear. So a warm welcome back to UCL, Elisa. We are very pleased that you are here. Turning now to my very dear colleagues as well at UCL, Professor Philip Sands and Professor Martin Paparinskis. I possibly mispronounced that, Paparinskis, sorry. Both are very well known for their outstanding contributions to the field of public international law, far too many for me to name here. So I will just say a couple of things by way of very brief introduction. Martin is a professor of public international law at UCL Faculties of Laws. He's also a member of the UN International Law Commission and is chair during the 76th annual session that took place this year in April-May, and also, for our purpose, represented Latvia in the ICJ climate advisory proceedings. Professor Philip Sands is a professor of law at the Faculty of Law, and as a practitioner and barrister, he appears often as a counsel before the International Court of Justice and other international tribunals in numerous cases. He also sits as an arbitrator, international arbitrator, and perhaps the best of all things that he does, at least for some of us in the audience, he loves writing about international books. He writes wonderful books about international law, which I'm sure many of you know and have enjoyed reading them as much as I have. So following this brief introduction, I turn back to you, Justin, to start our discussion of the court's opinion, starting with the first question that was addressed to the court, question A, which read, in very short format, what are the legal obligations of states under international law to ensure the protection of the climate system from greenhouse gas emissions for states and for present and future generations? What are your views, Justin, on what are the most significant findings in this opinion on both the climate treaties and customary international law, particularly from the perspective of those states that you've represented, the vulnerable states, small island, developing states, and other states in these proceedings, which really mounted a monumental diplomatic effort to bring these proceedings before the court. 5 minutes.
Thank you. Thank you, Gracia. I actually started my clock for 5 minutes. And thank you for being here.
You don't need to stress.
And thank you for the invitation. And of course, welcome to all the students, and thank you for the warm reception. I would like to start off by saying there could have been no ICJ without a gentleman called Solomon Yao, who was the leader of the Pacific Island students fighting climate change. And just yesterday, I was pleased to know that the Pacific Island students fighting climate change actually won the Right Livelihood Award, which is an alternative Nobel Prize award. So I think there should be some kind of recognition of that. At the beginning, I was cautiously optimistic because, we have 15 judges who are from different legal backgrounds, different trainings, China, India, America, France, Brazil, and a lot of heavyweights. And I just thought that even though we produce good arguments, you never knew how these things could go. If I have to give an overview of the ICJ itself, in the room, well, we were there in December and I went back in July. in the room while the court was delivering their judgment, there were a lot of gasps, a lot of shocking surprises, I think. I was sitting down next to St. Lucia on my right, Bahamas on my left, and everything was just like, that is what we argued, this is what we argued for, and this is what judge think we had to do, and I'm just like, calm down, I just want to listen to the judgment. But yes, everything, it was like we were just ticking boxes, right? And so I was very surprised. So I'll just get into the first thing which surprised me was, well, not really, but the first immediate reaction that I think was important was the lex specialis rule. They said that some countries, including the state where we are now, said that the core treaties to rely on, or the only treaties we could rely on, is the Paris Agreement, the UNFCCC, the Framework Convention, and the Kyoto Protocol. And you could disregard anything else, such as human rights, customary international law. Of course, it lost the International Tribunal for Law of the Sea, dealt with that particular issue and said lex specialis rule doesn't apply, but we just wanted the court to actually reconfirm that. And the court said there are other relevant applicable laws, directly relevant applicable laws, such as, for example, the UN Charter, the UN Declaration for Human Rights, UNCLOS, Convention on Biological Diversity, etc. So that was, and human rights, international human rights. So that confirmed that climate change is actually not only environmental issue per se, but a human rights issue. So that was one thing that I think was cleared up, and I think we needed that as well from the court. And then we went into the temperature goals. As we know, under the Paris Agreement, Article 2.1 sets out what the temperature goals are, well below 2 degrees Celsius, to limit global warming well below 2 degrees Celsius, or to pursue efforts to reach 1.5 degrees Celsius. And the court actually said, well, it's scientifically proven that the target we should all be looking at is at 1.5 degrees Celsius. So essentially, it kind of threw out of the window the 2 degrees, essentially. That's, of course, a debatable issue, but it practically threw out the 2 degrees Celsius limiting of global warming pre-industrial levels. And even we argue that even at 1.5 degrees Celsius, it still had devastating impacts for small island developing states. Scientists have said that, IPCC reports have said that, the 2023 summary for policymakers, that you will still have sea level rise, you will still have intense hurricanes or cyclones, depending on where you are. And even to do that, we have to have deep and rapid cuts and immediate cuts of greenhouse gases. So that was something, for this decade, we need that. So that was something that was important, I think, for small island developing states. Quickly, I turned to NDCs, nationally determined contributions. That was also relevant because the court said that this is not something that you procedurally do. These are like targets individual states have. So it's not something that you do at your whims and fancy. Okay, I'm just going to put in my NDC, and this is a procedural thing that I have to do. It's something that the court said is a legally binding obligation, and it's an obligation of result, not necessarily conduct. Duty to cooperate. States have a duty to cooperate. That was the heart of the right, left, and center of this opinion. And the court looked at the UN Declaration, the UN Charter, which was adopted in 1945, and it said that states have a duty to cooperate for international cooperation for matters of concern, which was not even, climate change wasn't even a real concern in 1945. And I just want to touch base briefly on the customary international law. I know I'll come back to it in the second rounds, but there are two items of customary international law that were very important for us. Was that duty to prevent significant harm to the environment. The court said that applied not only to transboundary matters, but also to greenhouse gas emissions. And that was the first time that was tested, that whole duty to prevent harm, whether that no harm rule could apply to climate change. I think my 5 minutes is up, but these are just some of the issues, and I'm sure I'll get an opportunity to actually re-emphasize or to reassess or to answer any queries on this particular issue. So thank you very much.
Certainly, Justin. Thank you very much for keeping with time. We all have been taking a lot of notes already, so there will certainly be follow-up questions. I'm now turning to Martins, who's going to touch upon another area of the advisory opinion. So we heard about the climate treaties and customary norms, but the court also addressed the obligations of states under the law of the sea, and UNCLOS in particular, for the protection of the marine environment, and in particular the issue of sea level rise as an existential risk for small island states and low-lying coastal states. And I was wondering, Martin, whether you could offer some reflections on that part of the opinion, particularly also in light of the work that the International Law Commission has done on the subject.
Indeed, Gracia, many thanks for putting this together and for moderating so wonderfully. Indeed, the court said quite a few things about UNCLOS, but I think regarding the environmental protection matters, it broadly endorsed the approach that had been taken by the Law of the Sea Tribunal. So let me focus on, as you said, the perspective of the International Law Commission. So the Commission has looked at the topic of sea level rise in relation to international law since 2019, and this summer it adopted the final report of the study group. So for aficionados of ILC procedure, it's important that the Commission adopted it rather than merely took note, as it had done regarding some other study groups. So a very strong endorsement. Mm-hmm. And the study group looked essentially at three distinct issues, albeit appreciating their interconnected matter. The first was law of the sea. And in that context, the question at its core related to a rather technical issue regarding the drawing of baselines that UNCLOS requires to draw at the low water line, and then from them, correspondingly, maritime entitlements are extended outwards, including the important entitlements regarding fisheries in the exclusive economic zone and resources in continental shelf. And the question whether with the physical movement of sea level, the baselines and accordingly entitlements are affected. So that was one stream of discussion. The second one was statehood. The question of whether submergence of land, or more likely in the close term, effects on inhabitability of territory affect statehood more generally. That is traditionally conceptualized as territory of population and government. And the third theme was protection of persons, on which I will not touch upon. So I'll say something on the first and something very briefly on statehood. Essentially, starting from 2019, the Commission debated various ways of conceptualizing the matter. And so the mainstream view at that point probably was that UNCLOS does not directly address the issue of climate change-related sea level rise. And there are a number of ways how to read the implications. And probably most people thought that the implication is that baselines are ambulatory, in the sense that with the move of the sea level itself, the legal entitlements or the requirements to redraw the baseline are also affected. There are some points on which UNCLOS does provide for a certain degree of permanence, but those are very particular contexts, deltas and continental shelf. And so one way would be to try to reconceptualize the traditional approach regarding the starting point of maritime entitlements, or other people said perhaps the right way of thinking about it is try to freeze the outer limits of maritime entitlements rather than a starting point. Or yet other people said perhaps we should rather be even more creative and disentangle various rights, powers, and obligations inherent in there. And so overall, the debate went in the direction of the first possible solution. The sense, particularly promoted by the small island developing states themselves, starting with the Pacific Island Forum 2021 declaration, that there is something particularly inequitable, that small island states that have contributed possibly least to climate change are those that suffer most. That UNCLOS does not require updating of properly communicated baselines and maritime charts, and that on the contrary there are good policy normative reasons to view them once communicated as a legally valid and not requiring change. And that was essentially the approach that the Commission took, and one that the International Court endorsed by explicit reference to the ILC work, which I think was a rather rapid endorsement by the standards of development of international law. ILC report comes out in June, ICJ references it in July. Let me say something very briefly on statehood. So statehood is sort of the more general question. How do we think about the matter? Do we think about it in terms of creative rethinking of the criteria of statehood? So some people might say, well, if we accept the law of the sea argument that baselines are to some extent fixed, perhaps one could say that for legal purposes, space within baselines would count as territory, even if it is, physically speaking, beneath the water. And then perhaps one could say that international law requires that the Montevideo criteria are satisfied, not satisfied in a coextensive space. So it may well be the case that territory exists in one space, government elsewhere, and territoriality and peoples elsewhere. Or perhaps we could rely on self-determination, other important considerations like existence and membership of international organizations to maintain properly established statehood. So debate is just starting. And in my view, the court captured very well the fluidity of the legal situation at the moment. And it said in a single sentence, once a state is established, the disappearance of one of its constituent elements would not necessarily entail the loss of its statehood. And that strikes me as precisely the right thing to say in advisory opinion in the context where the law is manifestly in flux, providing an openness to development of more specific rules on this issue. The fact that this is also in line with what Latvia argue in the case is just an incidental benefit.
Thank you very much, Martins. Now turning to you, to Philippe, to offer some first reflections on the second question addressed to the court, question B, which was about the legal consequences for states that by their act of omissions breach one of the climate obligations that we have just discussed. Oh, sorry, my head. It's not Philippe, it's Elisa. I jumped some, sorry.
That's okay.
I was.
I'm sure we can work
No.
either
I'll
way.
I'll go to you. Sorry about that. So Elisa, that's what friendship does over the years. Too much confidence.
She already knows, she can already read my mind what I'm going to say.
Anyway, so Elisa, the question for you anyway was quite predictable, for, possibly for the audience. I'm going to take you to the part of in the advisory opinion that concerns international human rights law. In your position as UN Special Rapporteur on the promotion and protection of human rights in the context of climate change. And essentially, I was interested in knowing your reflection on the cause reasoning regarding the content and function of the human right to a clean and healthy environment. Apologies again.
No, not at all. No, and thank you so much. This is such an honor to share the podium and share reflections on what I think the whole world, based on experiences I've recently had in New York, in Geneva, online with many colleagues in different regions, as we're all unpacking and processing the historical contributions of the ICJ through this advisory opinion. But also the incredible story of this advisory opinion. And I want to echo Justin's words about how incredible a history of youth leadership, of Pacific Island states leadership, of countries most affected by climate change, and how their own truths, their own legal arguments have effectively been played back in the advisory opinion of the International Court of Justice. And I'm borrowing the words of the ambassador from Marshall Islands in Geneva, who was, I think, present at the reading of the advisory opinion. And there were indeed gaps, and we'll get to that in a minute. Of course, for the international human rights landscape, ecosystem, there has been so much clarification of both the evidence of extensive and increasingly compounding impacts on human rights of climate change in some regions of the world over 10 years, but now, unfortunately, in the last few years, it is really a global phenomenon. And a very extensive body of progressive interpretation of international law in relation to how the whole body of international human rights provides clarification about state obligations in the context of climate change. But despite the fact that the Paris Agreement does contain a reference to human rights, we haven't really seen a take-up and meaningful influence of human rights in the context of many states in relation to their climate action. So the recognition of the court of the centrality of the human right to a healthy environment as a precondition for the enjoyment of many human rights, as inherent in the enjoyment of human rights, and as essential for the enjoyment of human rights, is certainly a very significant part of the advisory opinion, and also that kind of statement of fact that it is difficult to see how the obligations clarified across the advisory opinion can be fulfilled without at the same time ensuring the protection of everyone's human right to a healthy environment. And that is part of a broader clarification that international human rights law as a body of international law is applicable to climate action and to the interpretation and application of international climate law, very much deriving from the earlier clarification that international climate change law is not lex specialis. And I think what is to me the most significant contribution of the human right to a healthy environment, as opposed and in addition to its interdependence with the other human rights, is really that understanding of the interconnectedness of all elements of the life supporting system on our planet, which again the court also clarified in terms of applicable law, both reiterating the findings of ICLOS, that of course the law of the sea and its provisions on the protection of the marine environment, but also the Convention on Biological Diversity and the Convention on Desertification and Land Degradation are all applicable to international climate change law. And all of that, to me, is something that is, I think, reflected also in the Inter-American Court of Human Rights advisory opinion, which preceded by a few weeks that of the ICJ. And we find in different terms also in the ICLOS advisory opinion, particularly the second part of that advisory opinion, when we see that clarity, both scientific and legal clarity about how marine biodiversity, marine forms of life need to be protected from the impacts of climate change, and that conservation as well as restoration is essential mitigation and adaptation action. And again, this shouldn't be a surprise from a point or from very basic readings of the international climate treaties, which have always indicated that the climate system is part and parcel of the other life-supporting systems on our planet. And yet, to this day, as recently as in May at the climate intersessional negotiations in Bonn, I was part of the very same discussions that have been going on for 15 years about how we can ensure climate action that is supportive of the protection of biodiversity, that is supportive of prevention of land degradation and desertification. And despite very clear scientific understanding, and despite the fact that from a human rights perspective, the climate action at the nexus with nature is essential for the protection of water, food, and health, we are not really seeing that as a prevailing interpretation, and certainly not as a significant form of climate action, including climate finance. So to me, that legal recognition of the human right to a healthy environment is also reflected in other parts of the advisory opinion when we had that systemic reading of international law and the emphasis on not seeing climate change as an isolated issue, moving away from what has been a dominating carbon tunnel vision of the climate problem, and which in many ways explains why climate action has not been efficient and has not prioritized the type of state conduct that would have scientifically been the most effective to prevent further harm to the climate system and further harm to human rights.
Thank you very much, Elisa, also for keeping to time. Lots of insights here to discuss in the second round. Now I'm really turning to you, Philippe. Sorry. I have changed the order of the questions slightly afterwards. It's not that I'm that confused, so you will adapt. But now I am turning to Philippe to the second question that was addressed to the core question B, which concern the legal consequences for states that by their acts of omission breach these climate obligations that we've been discussing under the climate treaties, customary international law, international human rights law, and law of the sea. And here, the answer of the court was rather straightforward, is that the customary rules on state responsibility are applicable to the determination of the legal consequences for these wrongdoing states, for states that breach these climate obligations. This is quite attractive, I think, as a matter of principle for any international lawyer, but questions have been raised as to how the application of the state responsibility framework is going to work out in the particular context of climate change in practice. And I wanted to ask you, Philippe, if you have some thoughts on this point and whether you foresee any challenges given the special features of the climate change phenomenon.
Thank you, Gracia, and also thank you for all the work you've put into this event. It's incredibly gratifying that so many of you are here and attending. So it is a remarkable advisory opinion, I think, by any standard. And I join in expressing real commendation to those around Justin and Justin himself who really made this happen and sent a signal to the judges of the International Court that for that generation this really, really matters. And I know from speaking to the judges that that had a very, very big impact. Context is everything when you understand a particular text. The first case I was ever involved in at the International Court of Justice was an advisory opinion on the legality of the use of nuclear weapons back in the mid-1990s. And in certain respects, it was a positive opinion. The court, for the first time in its history, said the protection of the environment is part of the corpus of rules relating to the protection of the environment, that international law is protected by customary and general international law. But also the court said, in really most dismal terms imaginable, a state is free to use nuclear weapons in circumstances in which its very survival is at stake. And it was a 7-7 split, with the president then casting his presidential vote. And from that, and then the cases that followed, to be honest, for about 20 years, I took a pretty dismal view about whether this bunch of judges on this international court had the capacity to deal with the kind of issues that Justin and others were so motivated by. That position changed in my mind in the early 2010s, and in particular a judgment in a case brought by Australia against Japan in relation to scientific whaling under the Antarctic Convention, when for the first time, and I'd done quite a few cases before the court, the judges rolled up their sleeves and got their hands filthy with the muck of evidence and showed they could deal with complex scientific evidence. And that effected a change in my thinking about it. And the consequence of that was that when Robert Carnwath, who's, I'm so delighted, with us today, invited me to give a lecture in the Supreme Court here in London on whether there should be an advisory opinion before the International Court of Justice, I changed my view and said, yes, there should be. My position up until then, because it's been a long game trying to get this wretched advisory opinion to the court, was no, I just don't trust these judges. But that changed, and in 2015, I expressed that view publicly. I have to say, I continued to have a certain skepticism. Justin and I have talked about it a lot, because I worried about the propensity of the International Court to sort of cut the cake and give something to all sides. That's often how they work. They didn't do that in an advisory opinion that came shortly before this one in 2019 on Chagos, and that signaled to me that there was at least the possibility. But in relation to the question that you ask, I think this advisory opinion goes a whole lot further than anyone could reasonably have imagined it might go. And the most significant thing about the advisory opinion is that it's unanimous. We haven't said that so far. That gives it a force that makes it very, very different from one where you have a divided court. And the fact that all 15 judges could coalesce around what they said on the issues that have been talked about and on the issue I'll mention very briefly now, is extremely significant. First key point, the court said this isn't only about treaties. There's customary rules of international law that govern, and that's hugely significant. It means that if you opt out of the treaty regime, you're not off the hook. And I have no doubt that was directed explicitly at the United States and the administration of Donald Trump. Because it's basically saying, tough, you are subject to these rules, irrespective of whether you're a party to Paris, the UNFCCC, or whatever. And that is a courageous thing to have done at the time that certain administrations are sanctioning judges on international courts and tribunals, believe you me. The second thing the court did, which is remarkable, is, it's not been much mentioned, but at paragraph 437 they said, the scientific evidence adduced in these proceedings establishes that significant harm to the climate system and other parts of the environment has been caused as a result of anthropogenic GHG emissions. It's happening. For me, that's the single most significant paragraph in the entire opinion, because I've always thought that the only thing that really matters with this opinion is the court's determination of the science, not for what happens at the international level, apropos your question, but for the implications at the national level. Because this is an opinion that's essentially written for national courts, because that's where the rubber's going to hit the road. That's where the real action is going to be. It's not going to be at the international level, at least in the foreseeable future. And this opinion allows national judges to say there's a unanimous decision of the International Court of Justice which says X, Y, and Z. And then they go to the next stage, and almost unbelievably, they say attribution isn't a problem. We can, it's paragraph 432 if you are interested. The rules on state responsibility admit the possibility of determining the responsibility of states in the climate change context. And then they put in a slight caveat, it's going to turn on the particular facts and that's a matter of evidence to be argued, but attribution is not a problem. In other words, the fact that 200 countries around the world are contributing in different quantities, temporarily in the past and today, does not preclude the application of the rules on state responsibility. That is a huge finding, and it is devastating for countries like Russia, United Kingdom, France, and so on and so forth, that argued otherwise. And then they go on and they say, in relation to causation, and this is paragraph 438, while the causal link between the wrongful actions or omissions of a state and the harm arising from climate change is more tenuous than in cases of local sources of pollution, this doesn't mean that the identification of a causal link is impossible in the climate change context. It merely means that the causal link must be established in each case through an in concreto assessment while taking into account the aforementioned elements outlined by the court. And what the court says in these incredible paragraphs is you can go against a single country. You don't need to go against all the countries, but if you can prove that one country has made emissions that have caused particular damage or contributed to the cause of particular damage, not exclusively responsible for that damage, you can go against that particular country. And I think that is enormously significant. I've been particularly interested in these aspects of the advisory opinion, because the next book that I'm writing is on ecocide, which is the criminal responsibility of individuals for going beyond what international law allows. And these paragraphs plainly allow the case to be made, in my view, that those who contribute, who say, for example, the science on climate change is a con job, words that you will have noted were responded to very forcefully yesterday by Pope Leo XIV. Those kinds of individuals who strip out climate change actions from their national legal system are on the hook for individual criminal responsibility as well as state responsibility. And those who assist such persons, and that will include lawyers and scientists, are personally on the hook. That is the way this is going. That is the direction that is being taken. I think mostly it will not, in the next 10 to 20 years, happen at the international level. The foundations will be set, but this sets the framework for extraordinarily far-reaching actions at the domestic level. One final word in terms of context, and I think it has to be said. We were talking about this before we came to the meeting. International law today is under fundamental assault. And I'm not going to mince words here. There was an extraordinary article written in the Financial Times last Saturday by a wonderful Italian writer, Giovanni da Empoli, which made it very, very clear that the agenda of the populists and of the technocrats is the total destruction of the legal order. Not change, total destruction. And you have to read the opinion of the court in that context. The judges are aware of what they are up against, and they are articulating what they have articulated as far-reaching as they have done, as a way of saying, okay, may the battle lines be drawn. We are going to defend the rule of law in international relations. And that's how I read this extraordinarily far-reaching and crystal clear decision. I don't buy the argument they could have done more on this or on that. It's an extraordinary opinion, and I think no one really expected it.
Thank you very much, Philippe. So I'm turning back to you, Justin. And following a bit the trend set by Philippe on the panel to think about the broader implications of this opinion, we heard in your first intervention a lot about what is good in there for small island and developing states and vulnerable states. And I wanted to ask you now the opposite question. Do you think that there are aspects of the opinion that could have gone or should have gone further, where the court should have gone further, in particular when it comes to this country's claim for climate justice within the UN climate regime?
Yeah, thank you again. And just to echo what Philippe just said, at the ending there, it is an extraordinary opinion. There are some things, of course, which you'll always say there are some things that could have gone further. But I think there are more things that are better than saying it should have gone further. So, for example, cooperation, they said, is not a choice for countries, but a legal obligation. So cooperation in terms of financing, climate finance, and debt relief. We have seen two leaders in the Caribbean. That's Deacon Mitchell, Prime Minister of Grenada, and Ralph Gonzalez, actually three, St. Vincent and the Grenadines, and Gaston Brown from Antigua and Barbuda, stating that after Hurricane Beryl hit in 2024, writing David Lamy, the Foreign Secretary, who's now Deputy Prime Minister. David Lamy is also a descendant from Ghana, from the Caribbean, saying that we want immediate debt cancellation, for example. So we see that that is something positive. So now we can say if the ICJ is saying cooperation, which means, for example, debt relief, states must communicate with respect to that, developing countries. That is also applicable. What, in my mind, what I think, now I don't really want to stress it too much because we got more than we wanted, but what could have gone a little further, if I had to say, was the whole idea of trusteeship of the environment. And this is something that we strongly, when I said we, Caribbean countries also strongly argued for in terms of future generations, that states have an obligation to hold the environment in trust for future generations. Right? Paragraph 156 mentions trusteeship, and if I call out, they said intergenerational equity, which is the ability to hand over the earth or the environment in a condition at least you should inherit an earth at least as good as that of the previous generations, right? So the current generation should inherit an earth that is not worse off, at least the same, right? And intergenerational equity is the expression of the idea that present generations are trustees of humanity, which is good. But we wanted to see that whole idea of trusteeship. What is trusteeship? And how should it enable states to hold the environment or the climate system in trust for future generations? And I would have also liked to see trusteeship of the atmosphere, right? what does the atmosphere mean? The atmosphere is part of the climate system. But we were actually arguing, just as climate change is a common concern of humanity, why can't the atmosphere also be a common concern of humanity? So this is something that because atmosphere is part of the climate system, right? So this is something that we, and that would continue the work of the ILC, because the ILC is, they did a lot of work on what is the legal status of the atmosphere. And they focus on and saying that the degradation or the protection of the atmosphere is a common concern. But some members of the ILC wanted to see that the atmosphere, not the protection of the atmosphere is a common concern, but the atmosphere itself in totality is a common concern. And states like St. Vincent and Grenadines, Grenada, I think St. Lucia as well, argued that the atmosphere should have some legal status. But the court didn't touch upon it. But that's okay. We always, we may lose the battle, but we may end up winning the war somehow in the future. But I think at the end of the day, if I had to touch on those things, it would have been to give that advisory opinion an extra push. But be it as it may, we got more than we deserve, and we are thankful for that.
Thank you very much, Justin. Now I'm turning to Elisa, and that is a purpose change, not that I got lost again in the order, and then I'll go to Martin's. I wanted to take you and have your views on what has been possibly the single most commented paragraph in the advisory opinion, and that is the court statement on fossil fuels. Which says, I will read it for the benefit of the audience, failure of a state to take appropriate action to protect the climate system from greenhouse gas emissions, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel subsidies, and fossil fuel exploration licenses might constitute an internationally wrongful act which is attributable to that state. What are your views on this statement, Elisa, in particular in light of your recent report on the imperative for defossilizing our global economy?
Yeah, thank you so much. I think that was one of the paragraphs that elicited some gasps in the room, I understand. And I think for very good reason. I mean, one of the continuing problems within the climate regime, an aspect of denialism compared to the truth, the legal truth, the scientific truth, and once again, the lived experiences of those most affected by climate change, is that it's still a taboo to talk about fossil fuels in several fora, not just in the climate system, in the climate regime, even if the science has been for a long time unequivocal that fossil fuels burning is the main cause of climate change. Now, again, I'm talking about a reality of international relations that has been confirmed only a few weeks ago. In August, we had the next phase of the negotiations of an international plastics treaty, which again provides an opportunity for developing treaty norms on phasing out plastic production, which is very linked to fossil fuel production and, in fact, expansion. And yet it was not possible to have that mention, and in fact the negotiations almost collapsed, and it is unclear now how they will be resumed. This is also true for the Human Rights Council. Despite discussing my report on the human rights imperative of defossilizing our economy, a few weeks after states were negotiating a recurrent resolution on human rights and climate change, and it was not possible to mention explicitly fossil fuels. And so in a way, this to me, this and the accompanying, I think, language in the court about reflecting on the fact that internationally wrongful acts in the context of preventing further harm to the climate system are not just the emission of greenhouse gases per se, but the fact that states need to exercise due diligence in how they regulate the activities that foreseeably, and in fact in some cases with full scientific certainty, cause climate change. And that is, I guess, echoing what Philippe was saying, that points to very specific countries and very specific state conduct. We have very recent reports showing how fossil fuels are expanding, despite the fact that we have very clear scientific evidence that climate change is worsening and that we're not being able to stay within that 1.5 degree average temperature, even if hopefully we can go back from that. And to me, what is important is that the court made this clarification in the second part of the advisory opinion, thinking about state responsibility and giving the clear indication that there's very easily identifiable state conduct all the way to licensing for exploration of fossil fuels, subsidies, as well as not only consumption, which is linked to that scientific evidence about burning fossil fuels, but in fact the extraction of fossil fuel in and of itself is a demonstration that states are not exercising their due diligence, even considering differentiated capabilities in the context of preventing further harm to the climate system. And maybe one thing about my own report, I should mention, as opposed to the other advisory proceedings, UN special rapporteurs were not able to contribute either to the written or oral proceedings before the International Court of Justice. And this is why I decided to prepare my thematic report on fossil fuels with some anticipation compared to the issuing of the advisory opinion of the ICJ. And what I did in that report was not only looking at climate science, which also shows that every single stage in the life cycle of fossil fuels has negative impacts on the climate, either directly but also indirectly by leading to biodiversity loss, to toxic pollution, which in themselves undermine the capacity of the planet to regulate our climate system, and with all the impacts on human rights that are in addition to the human rights of climate change itself, and once again undermine human resilience in the context of climate change. So there's like multiple layers of human rights violation that derive both from the contribution of fossil fuels to climate change, but in fact to the understanding that fossil fuels are at the root cause of all planetary crises we're facing, including the planetary crisis of economic inequality. And because of that broader range of scientific evidence, and particularly an incredible report on the health impacts of fossil fuels from cradle to grave, which I invite all of you to read, that kind of evidence shows how the phasing out of fossil fuels, it's both a matter of international climate change obligations and interlinked international human rights law obligations, but it's also a matter of protecting your own people in your own territory because of their human right to health, human right to life, children's rights to development, and it is a matter of here and now. All our organs are affected by fossil fuels. We have plastics in our brains, in our reproductive organs, in the maternal womb when children are expecting to be born. And that is on top of the petrochemicals that together with plastics are in all our food systems, with again negative impacts on nature and on human rights that undermine our capacities to survive in the context of climate change. And that shows why we need to move away from this very narrow understanding of decarbonizing our energy systems. Of course, we need to do that, but what we need to do is look deeper about the transformation of our economic systems and follow the tracks of the fossil fuel industry, who was expecting this legal clarification sooner or later, and has already expanded on the front of plastics, on the front of petrochemicals, and on the front of attacking international law and undermining everyone's access to information on climate change and human rights, which undermines our democratic systems as well.
Thank you so much, Elisa, for these very powerful reflections on the court statement. I'm turning back to Martins and Philippe. We are supposed to finish in 1 minute, so I'm being a terrible chair. But we also started late, and I have to say that it's very, very difficult to interrupt people that are making these powerful statements, all of you, at least for me. But I will please ask Martins and Philippe to try to keep their intervention to 4 minutes, maybe? Yeah, 4 or 5 minutes. So, Martins, we've been hearing a lot about how the court approached treaty and custom and how the two sources of international law interact. And I wanted to know whether you have any further reflection as to what this advisory opinion means for the relationship between these two sources more broadly.
Thank you, Gracia. Of course, and indeed, as was said, this was a point that was at the core of the case. United Kingdom, for example, the Attorney General made essentially two arguments. The first question was whether, in relation to customary international law, it is applicable outside the context of contiguousness of a dispute. So, Corfu Channel, one country next to the other, pulp mills, Argentina and Uruguay. And so that was the argument that the court rejected. But to some extent, really, the key argument in the case was whether, to put perhaps more bluntly in terms of lex specialis, but what is the weight that treaty arguments carry in determination of customary international law? And there I have to say I have a degree of ambivalence in reading the opinion that even though the blunter argument about lex specialis were rejected, the fallback argument of the United Kingdom was that even if customary international law applies, the determination of its content and relevant circumstance of application has to fall back on the treaties themselves. And there, it does not seem to me unreasonable to say that the court actually was quite receptive to the argument. So when it looks at the climate change treaty rules and customary rules, it essentially says that, makes some fairly well-known observations about relationship of sources, treaties may give rise to custom will be taken into account in interpretation of treaties. But how do we think about the satisfaction of criteria of customary rules when we think about the treaties? And there, first, the court says, well, with a nod to what ITLOS had said in its advisory opinion, in many respects, compliance with the treaty obligations will bring you in compliance with the obligations under other rules. It is not automatic, but in many respects it is important. Now, in relation to non-parties, and presumably, as Philippe suggested, with an eye to particular states, the court used the idea of the presumption of compliance to the extent that a non-party state does essentially the things that a party would. There's a presumption of compliance. Otherwise, the burden of proof, as it were, is on the non-party that can choose a different route. And it raises very interesting, I suppose, conceptual and as well as practical questions. What exactly is going on here in legal terms? So how do we disentangle treaty and custom? There were several judges who wrote separately, who were very insistent, led by Judge Charlesworth, that these are complementary but autonomous rules. But it is very, very complicated indeed, and in some ways their argument itself shows that. So they quote a wonderful, wonderful sentence from the much missed James Crawford, who contrasts treaties and custom by saying, custom is like a long-running conversation. Customary law is like coffee. It has to brew. Treaty captures a particular moment, which is right in general, but of course it is patently wrong here. In the context of the climate change treaty framework, the coffee is brewing all the time, so it's very complicated to untangle. So what is going on there? Is it customary law taking into account treaties as relevant standards of application, which is one thing that could be going on? Are those COPs, the conferences of parties, contributing to custom? Or perhaps, and I think I like the rather pragmatic point made by Judge Tladi in his declaration, it is not normative. It reflects the pragmatic consideration that is where the tension of states is focused at. And so that, I think, is perhaps actually a rather practical message for states, both parties and non-parties, that non-participation has its costs. And non-participation without the creation of, again, to borrow from Judge Tladi, other games in town on matters that are legally relevant will come with the cost of being unable to shape the development of the roles in the area. So there's, in a sense, a pull factor. Being part of the game is good. It enables you to shape the conduct. Otherwise, you have to provide your alternative ways of shaping legal rules on the issue. Doing nothing at all might have the implication that one has to live by the rules shaped by others. So there are, I think, very pragmatic, good reasons, in a sense, to be part of a particular framework. So there's a principled point of which Philippe spoke very powerfully, but also the pragmatic, so the costs and benefits, good benefits for being part of the game.
Thank you very much, Martin, and also for keeping to time. So, Philippe, you have the honor of closing the panel discussion with your thoughts on the broader implications of this opinion. You already hinted at domestic rather than international climate litigation. You can elaborate on that, or you can elaborate on whatever you want. Just inspire us for the next 5 minutes.
5, wow. I'm going to follow logically from what Martin has said. I think he's really highlighted some of the issues that are going to come up in a very practical sense. And you asked me to think before we met about the implications for interstate litigation. I think this opens the door to interstate litigation, and one can imagine the kinds of scenarios that Justin has referred to in terms of, a major destructive weather incident which has a scientific basis as having been caused in part or in whole by emissions of greenhouse gases. I think we can now see the possibility of a state going against another state. And the kinds of issues that Martins has identified is then really going to concentrate the minds of the judges as to how they go about establishing whether or not a particular incident was connected directly to a particular set of emissions from a particular country. That's the practical issue, and it becomes even more complex when the country is not a party to the treaty regime. So I think these issues are ripe for brewing, to take the sort of Crawford kind of analogy. You asked also about investor-state arbitration, and that we're already beginning to see. There is a case that was filed against the United Kingdom just a few weeks ago in relation to limitations on coal mining in the United Kingdom. And we will have to wait and see how that is addressed. But you can imagine, and here I'm being very careful what I say, that an advisory opinion that is unanimous could be used by one or the other side in relation to making the arguments they make in relation to the interpretation of whether there's been an unfair or an inequitable approach, or whether there's been, in effect, directly or indirectly, an expropriation. My own experience, and Martins and I have talked about this a lot, because I sit as an investment state arbitrator, is not a particularly happy one in terms of what I've identified as a sort of generational divide. You sit often with people for various reasons. I got involved in the environment very early. I was one of the negotiators of the 1992 convention. So it has affected my being for more than 30 years. But I'm pretty rare for my generation. And so what you often sit with is people who've never taken a course on the environment or climate, who've never thought about environment or climate, and who, frankly, don't give a fuck about the environment or climate, and just proceed as though it's a nonsense, a con job. And that, I think, is where your generation becomes really significant. I'm speaking here to the students. You will be the generation of change. And I just want to put this in this particular context. This may all sound like highfalutin ICJ advisory opinions and so on and so forth. It's not. This really affects each of your lives. For those of you who are students now, you're going to face decisions about what you do with your lives in professional terms. You're going to get incredibly lucrative offers from law firms. And you will then have to look inside yourself and ask yourself the question, do I care whether or not they're acting for X or Y? There was talk about fossil fuels. I am less happy about the ITLOS advisory opinion for various reasons, but one of them is that it didn't address fossil fuels. And one of the reasons it didn't address fossil fuels relates to this point. The small coalition of small island states, and it was a very small coalition, not the same one as your one, a very different one from your one, was advised by a very major law firm. That major law firm also happened to act for Shell. And it's not beyond the realms of imagination. Yes.
Courses?
Yes. And it's not beyond the realms of imagination that the reason their pleadings made no reference to fossil fuels is that there was a sort of an articulation of commercial and, if you like, greenwashing interests in terms of getting involved in these things. You're going to face those issues. You're going to have to ask yourself whether you're willing to take the $300,000 a year you're going to be offered to go and work for a firm that is essentially arguing in that particular direction. It's an individual matter. I'm not saying it's right or it's wrong. It's for you to decide. But you've got to start thinking about these issues in a way that my generation did not have to think about these issues. And that is a big responsibility for each of you as you go forward. In other words, this advisory opinion is going to set the scene going forward at the domestic level, at the international level, but also at the individual level for each of you if you wish to take that decision one way or another. And that's a big responsibility.
Thank you very much. I think we still have time for some questions. I'm sure there are plenty in the audience. So are we using mic? How are we doing this? Kat? How she disappear? Hello. Okay. We don't have no... I repeat the question. Okay. That's maybe not the most effective way. But yes, please. Or speak loud. Any questions? Don't be shy.
Hi, I have a question specifically for anyone can answer. You spoke specifically about the interdependence of rights and how this decision kind of reflects the interdependence of environmental rights with a number of others. I was wondering if you could speak specifically to cultural heritage as a right through the UN Declaration of Rights of Indigenous Peoples, as well as if you'd like to expand on more through personal autonomy or reproduction, and how this decision maybe poses a new way forward for some progress in the development and advancement of those rights.
Yeah, no, thank you so much. A brilliant question around interdependence on rights, but also considering the disproportionate impacts on the human rights of certain individuals, peoples, in the context of climate change, and particularly indigenous peoples' human rights. It's also a question with your reference to cultural heritage that I think goes to the core of what science and what evidence we rely upon and whose worldviews we rely upon in crafting international law, in supporting evolutive interpretation of international law, and in then applying that in the context of, for instance, like climate action. So the ICJ recognized that indigenous peoples, but also children, women, and others, other human rights holders are more affected by climate change. And of course, the broader recognition that international human rights law as a whole applies to states' action on climate change means that also the specific branch of international human rights law concerning indigenous peoples' human rights applies. Now, this is again a very live issue. Every day I receive complaints and concerns from indigenous peoples around the world, including in our region, where climate action, including action for advancing on renewables, violate indigenous peoples' rights. And this to me says two things. First, that whenever there is a violation of indigenous peoples' rights, usually that means that there's also at least a risk, if not already an actual impairment of everyone's human right to a healthy environment. Because their intrinsic connection to nature and to those life-supporting systems, their knowledge systems relating to those interconnections provides, I think, an immediate understanding of where climate action is not being devised at the nexus of climate, nature, health, food, and water. But it also shows something deeper, that connection with inequitable and inherently destructive economic development approaches that explain why we're still expanding with fossil fuels and other deeply harmful ways of relying on natural resources for our well-being. And that leads me to that point around, and unfortunately in those debates, or I should add, we often, they are framed, including by public authorities, as an opposition between, well, we either protect indigenous people's human rights, or we protect society's broader interest in advancing on, towards a renewable-based economy and, broader society, economic and other benefits. And that, I think, is an inaccurate and, in fact, very unhelpful description, which goes against the interdependence on human rights and ignores the fact that often that violation of indigenous people's rights is a very meaningful indication of disregard for full protection of everyone's human right to a healthy environment in those interconnections. And often indigenous people's rights are also violated in their cultural aspects. And again, there's been some recognition more from the Inter-American Court of Human Rights, but also recognition from a Western science perspective. The indigenous science is, in fact, more advanced than our Western sciences in understanding those planetary interconnection, planetary health, and through that understanding the impacts in terms of human rights. And so often those violations of indigenous people's cultural rights also point us to, I think, a violation of everyone's human right to science, and that reliance of global scientific assessments around the value of protecting indigenous science and all the conditions that allow for that science to develop, be transmitted to future generations, and under some circumstances being shared with us for taking more effective climate action at that nexus.
Thank you. Yes, well, maybe I'm going to take 2 or 3 questions at a time. Yeah. You can say your name. That would be great as well. Yeah, introduce yourself briefly. Yeah.
I'm Joseph Borgerisi. I'm a Mexican barrister, among other things. I just wanted to probe Professor Sands' line of thinking with the individual responsibility standpoint. Looking at it from a litigation lens, obviously the advisory opinion has been groundbreaking from an interstate responsibility standpoint, especially when it has construed the obligations of the states as the omnes and construed as customary international law, potentially unlocking previously closed pathways through offshore law regulations. But I was just curious about that further points that Professor Sands made regarding the potential criminal individual liability. And yeah, just thought that I just ask about that specifically and see if Professor Sands could be add to it.
Great, thank you very much. I saw further hands over there. Oh, I don't know, there are too many. Yes, and yes, let's take 2 more questions and then we go back to you. Yeah, 2 more, yes?
I'm Nora Wendelberg, and I was wondering if you saw the blog post by Daniel Bodansky that talks about sort of the potential chilling effects of the conduct for the conduct of local climate policy diplomacy, with the negative consequences that the advisory opinion could actually have on these efforts.
Because of the globalization targets. Yes?
Hi, I'm Christina Crossman. I'm a climate change lawyer from the UK government, and I'm really interested in understanding your views on how the ICJ advisory opinion is going to affect negotiations at the COP.
Okay, so a lot of interest for the implications on climate diplomacy.
Yeah, I'm happy to respond on the climate negotiation side, but
Do you want to do the individual responsibility first?
maybe you want to.
Who wants to go first?
Maybe Justin
Yeah.
on
Or
the
Justin?
I can touch
negotiation.
on just that last point,
Yeah.
climate negotiations.
Yes.
For the COP, for example, the court said that the decisions of the COP could amount to customary or the identification of customary international law. So what the COP decides could form a corpus of customary international law. One may recall maybe 3 or 4 years ago in Glasgow when there was a decision whether to phase down or phase out coal, for example. And I think if that decision is to come up again in Brazil or whereafter in November, that they can point to the same provision that Lisa just pointed out, where states are responsible for producing fossil fuels or subsidizing fossil fuels. That could amount to international wrongful act, according to the ICJ. Well, may amount, right? So that is tantamount to saying that if states pursue subsidies, or if states actually consume fossil fuels, including coal, they could be actually singled out or for national or international litigation for their acts, because it may amount to international wrongful act. So I think if states come together and say, well, we now have to phase out fossil fuels because of this decision, that could equally over time amount to opinio juris, or amount to what we would consider customary international law. So I think that's a leverage, even though the ICJ opinion, which we haven't really fleshed out, is not binding, but the law that it applies is binding. Paris Agreement, UNFCCC, it is binding, and it also carries a lot of legal weight. So I think states, small island developing states, vulnerable states, can use that as their leverage to show that, listen, you can't really consume or you can't subsidize fossil fuels based on that, because else you would be liable to be sued under international law. That's something that vulnerable states can use. So I think that is just one example I would wish to point out.
Yeah, just very briefly on the last two questions. So on the chilling effect, I mean, to this date, the climate negotiations couldn't be chillier. I mean, COP29, we didn't even have a negotiation on mitigation. In Bonn, a few months ago, AOSIS was literally silenced for speaking up during what were supposed to be mitigation negotiations. And I think, to me, fundamentally, the premise of the article, it was the basis of many arguments made before the ICJ, and in fact, also ITLOS, around how the premise of the lex specialis was the states are carefully crafting the rules under the Paris Agreement. And in fact, what the court said is that is really not, has not been done in a manner that is aligned with international law, general international law, and other relevant applicable areas of treaty law. So in effect, there is a fundamental question of good faith in how states behave in international climate negotiations. This has come up to the surface in many instances, both in terms of agreed language of the process, of how the consensus-based decision-making is being abused, and it's widely discussed to a point where I think the climate COP is really facing an existential test at this Brazil COP 30. It has to show that it can be a meaningful forum where states engage in good faith in fulfilling their international duty to cooperate. And to me, then the impact of what should be the impact of the advisory opinion will be for states to negotiate in good faith by avoiding arguments that go against or below the standards that have been clarified by the advisory opinion.
Thank you, Lisa. You want to respond on the question?
Sure. I mean, just on that issue, Dan is a very fine person and a very fine lawyer, and we were together from 1989, 1990 negotiating the Framework Convention, and it's always been his position to be very cautious about litigation, and I think he's wrong. I think that basically the COP process has effectively come to an end, and you've got to find other ways of moving. And I think what is important about the advisory opinion is that it contributes to a change of consciousness. And I think that's the most significant thing about it. It's not, for me, the law is not a mechanical thing. It's how it works its magic in different ways. The question you asked, Joseph, is personally a very difficult one for me, and I'm trying to work out my own thoughts about it. So I'm involved, for example, in litigation before various international courts on maritime boundary issues. And in part, those maritime boundary issues are about bringing peace and stability between two states that have an issue of tension between them. But actually, as we know, very often, it's about creating a stable and clear legal framework which allows the countries and various companies to extract fossil fuels. And so I'm going through my own internal interrogation about whether I should be involved in this exercise of contributing to the resolution of boundary disputes, because the resolution of boundary disputes, on the one hand, is a good thing, on the other hand, may not be such a good thing, but where it is being done by very small developing countries that are very impecunious, is there not a sort of moral argument that equitable principles say to the extent that a fossil fuel budget remains, they should have a greater access to it than others who've already benefited from it. So these are really complex questions, but one of them concerns the role of the criminal law in all of this. And I am quite influenced by developments in the 40s in relation to the field of human rights. You know, until 1945, states could do whatever they want in relation to individuals and groups, and if they wanted to kill half the people in this room, they were free to do it as a matter of international law. The change that took place in 1945 was to say we have crimes against humanity and we have genocide. I read about this in East Westry. And, you know, we always knew it was never going to solve the problem and stop the horrors. You need to open, you know, your papers today and see what's going on in the world to understand that reality. But it has changed consciousness in terms of what are the limits, what's permissible and what's not permissible. And the whole of international criminal law is directed to the well-being of humans. There's nothing in international criminal law really about the well-being of the environment. It's one of the issues that I think needs further discussion on the work that Elisa does. I've always had a degree of skepticism about the connection between environment and human rights. And the reason that I have that skepticism, and it's not in any way to undermine or contradict the incredible work Lisa and so many other people are doing, is this. By linking the environment and human rights, you effectively commit the protection of the environment to an anthropocentric direction. And you essentially put, once again, the human at the heart of the whole thing. And I think, and I certainly don't expect it's going to happen tomorrow or even soon, what's actually needed is a much more ecocentric approach in which you essentially ditch the human and you say that actually there are certain areas in which rights for the environment themselves trump rights for the human. And so there is a fundamental tension, in my view, between the coupling of human rights and the environment. And as I've grown older, I've started off very skeptical about, you know, should trees have standing? To this day, the best law review article I have ever read by Christopher Stone, the single most important law review article I've ever read. You should all read it. It's all freely available on the web. And going in that direction. And that's essentially what the ecocide idea is about. Started in the 60s in Vietnam, taken forward in the 90s, and then a remarkable barrister who sadly is no longer with us, Polly Higgins, really pushing that idea. And so I think that's one aspect to think about going forward. It's not a critique, you've understood.
No, I have a response.
Polly. Let me take for sure you can, but let me take there were a few more students here in the audience. Yes, and at the back as well, I saw some hands before. They have all been addressed? They're at the back? Okay. You, Gerardo? Eusebio, pardon. Eusebio, and at the back? Ul.
Hi, my name is Eusebio. I'm from the Dominican Republic, so another small island developing state. And I'm also a climate negotiator for the past 3 years. I do share a lot of the views from the panel, but also I have my own. But I wanted to know, now that with this advisory opinion and a lot of the things that it addressed, I wanted to know what's your opinion on on how we could address the just transition approach that is coming up in the UNFCCC, especially now that the debate has collapsed over 3 years in a row and we have no direction over where to go in ensuring a just transition that leaves no one behind, which is a matter of human rights, social protection, social dialogue, and a lot of other realms of international law. And also on loss and damages, which was presented before as a question, immaterial loss and damages, cultural ones, especially for islands like my country, but also material ones. How we're going to we determine that. Maybe litigation could play a role in that. So I'm just curious to know your visions on those two issues related to climate. Thank you.
Thank you very much. Yes?
Hi, I am Purva. I'm pursuing the Master's of Law in Civil Rights. My question is that in the ICJ advisory opinion, there's an acknowledgement for the duty to prevent harm and also an acknowledgement to the fact fact that the state's status is not static. How does that affect differentiated responsibility in the long run?
Well, good. So we have lots of points here: loss and damage, common but differentiated responsibilities, and the status of countries not being static. Who wants to start addressing? You want to start addressing some of these issues?
Well, I could. Yeah.
Some thoughts.
Oh, yeah,
Yeah.
all of them are kind of interrelated, but some thoughts. First of all, this is the decade, I think, of the advisory opinions, right? Because we had Inter-American Court, it lost ICJ, and next year we'll have an African court opinion coming from the African Court for Humans and People's Rights, which is currently in train. I'll just touch briefly on loss and damage. The court did a very elaborate discussion on loss and damage, and they said the articles on state responsibility, which was drafted by the ILC, does amount to customary international law, and it went into different remedies. You have loss and damage, you have compensation, you have satisfaction, apologies that states could offer. So I think, again, that's another tool in the toolbox for COP negotiators to say, well, we could now vigorously pursue loss and damages. Because when you see, for example, in small island states, as my friend here, Dominican Republic, which was also party to the proceedings, the 10th Caribbean island, we had 9 CARICOM and 1 Dominican Republic, which is also CARIFORUM, so we appreciate that as well. But when you see hurricanes such as Maria in 2017 wiped out 200% of the GDP of Dominica, Hurricane Ivan in 2004 wiped out 270% of the GDP of one country. And Grenada, their revenue comes from the nutmeg tree. And Grenada, little do you know, Grenada is called the Spice Isle for of course, obvious reasons, because it's very small, 100,000 people or less, and they are the second largest producers of nutmeg. And when one hurricane comes out, within a matter of 24 hours, it takes 15 years for a mature tree to grow. Mm-hmm. And then within less than 24 hours, the whole nutmeg plantation is gone. And then you borrow money. Who do you borrow money to build your agriculture or infrastructure? You go to countries such as, you go to the IMF, of course, but you ask the UK, the US to give you a loan, and you get interest to pay back this loan. And then the next maybe 4 or 5 years, another disaster, probably even less, another intensive hurricane comes, right? And you keep on, so you end up in a vicious spiral of paying litigation and paying, interest and loans for damages that you have not contributed 0.01% percent of your greenhouse gases. You are, in terms of the global scale, you contribute, right? This is Grenada, and I'm speaking of Grenada here now. So I think when you look at that vicious cycle of debt that these countries are going into, now that you have this advisory opinion that says loss and damage is on the table, debt relief is on the table, I think these are definitely implications that states could look at and also negotiate the leverage that we're speaking about when it comes to COP negotiation, the injustice that comes out of it. So I think that's very important, the issues that you raise. I mean, there's something else, but I'll leave it in terms of duty to prevent significant harm, but I can leave that for maybe someone else if you wish to.
Martin?
Thank you, Gracie. I have 1.5 points. The half point is about fossil fuel, because there has been a very rich discussion on that. And I think it's obviously not disagreement with a normative stance, but perhaps I see a slighter degree of ambivalence in the opinion on this issue and other speakers. The explicit language of fossil fuel appears in 2 sections. In the section on scope, then it doesn't appear in answer to question A on the obligations, and when it appears in answer to question B, it appears in a subsection on questions of attribution. And within the conceptual framework of international law, we usually say that attribution is completely agnostic to the content of obligation. Of course, you have to have attribution and breach, but those are distinct inquiries. Well, probably the response is that, therefore, fossil fuel is something that is bubbling in the background to everything that is done in relation to primary rules. But I have to say that I see a greater degree of ambivalence than some others, and perhaps it really reflects the point that Elisa made about the greater controversy on these matters and sensitivity. And clearly these were issues that were before the court. Judge Cleveland writes quite powerfully about it. So there are issues that were, as it were, for the purposes of this opinion settled. Fossil fuels, I think, in the terms of, as it were, on the spectrum between clarity and vagueness, it's certainly not at the end where clarity lies. If I could just say on loss and damage, I agree with Justin. I think that there are many things that have been provided. The court said things on ergo omnes that, so that I think, in my view, to borrow what Philippe says, I think that perhaps went further than people expected. Some people might have thought that a question that is asked about legal consequences, which in terms of state responsibility framework goes to the content of responsibility, does not require speaking about implementation, which is a totally different body of law. The court did, and those were powerful things that it made, indeed, unanimously, indeed, without a particular controversy. I don't think that any of the judges in their opinions said that that was controversial. Now, of course, from the perspective of international law of responsibility, an important point of structural framing is that the obligation to provide reparation is independent from invocation at all. It is an obligation that arises out of the breach, and that may be implemented in various settings, in formalized judicial setting, possibly even domestically, and certainly within negotiations. And one direction, so something that Caribbean countries have done powerfully in the context of reparation claims for transatlantic chattel slavery, is commission of valuation reports and public presentation, very classic invocation responsibility through public diplomacy channels. So there's a variety of ways of going about it, and it could well be that in a traditional international law manner, we will have to wait for the right jurisdictional opportunities to arise internationally or domestically. But it certainly is also a sort of a change, reconfiguration of consciousness in this matter. So it is important, even if in an advisory setting, it doesn't give answers to all the practical questions.
Yeah, maybe on that point of just transition, I think this is an area where, for instance, international human rights law can be particularly helpful, both in terms of the process and how relying on the human rights-based approach can help to untangle and address fairness and justice issues in the transition. We just had a new report of the Secretary General prepared by the Office of the High Commissioner, conceptualizing just transition through the lens of international human rights law. And my own most recent report, which I'll discuss in 2 weeks at the General Assembly, is also about clarifying a human rights-based approach to the energy transition in particular. And I think it is the same for loss and damage. There's been significant normative clarifications from UN international human rights law experts and bodies that shows how that applicability of international human rights law is both helpful in terms of guiding states on the what and on the how of pursuing these areas and further clarifying those areas of international climate law and practice, but also in terms of the evidence of understanding what's unjust, what we're doing already wrong that should be redressed and it's preventable and should be not repeated. And maybe that helps me to address maybe the point that Philippe raised around...
You can keep that for later.
Shall I keep it for later?
Go.
It is true that, there's been a history of dominating view that human rights are anthropocentric. I mean, to me, the whole idea of anthropocentrism is true from some cultures and philosophies, but it's not true for every people around the world. Again, let's think about indigenous peoples' worldviews, also cultures. I'm thinking about Pacific cultures where we are the ocean is one of the understandings. And so that anthropocentrism is not an issue for all people, and we should recognize that as a I guess, nosological issue. But equally, there are areas of international law where we recognize that humans and culture are parts of nature, how the ecosystem approach has been clarified under the Convention on Biological Diversity, and the fact that both ITLOS and the ICJ relied on the ecosystem approach or the CBD, to me is significant to show this is the direction of travel, this is where we get things wrong and how we can adjust. And the science is also, I think even Western science is now moving towards a more interdependent understanding of planetary health and human health, understanding that our faces are territories of microbes, that our own microbiome reacts to the interaction with microbes in our environment, to the point that when we're coming out of surgery, we recuperate in half of the time if our hospital is next to a diverse forest. But maybe another way, and ultimately if we are to rely on law, which is a human instrument, we do need to maybe focus, I think, on and supporting those interpretation and applications of law that really rely on that indissoluble interconnectedness between humans as part of nature. Interestingly, in the Inter-American Court, which I think relied and discussed nature's rights, relied, I think, a lot on also testimonies from indigenous peoples' representatives, have found that the protection of the climate system and, in fact, life-supporting systems is customary and use cogens on the basis of a principle of effectiveness. Now, this is maybe one of the most debated findings from the Inter-American Court, but I personally find that as a matter of law and as a matter of fact, it is true. And we often say it recently the Committee on Economic, Social and Rights said it, there are no human rights in a dead or unlivable planet. And the whole architecture of international law is becoming ineffective, at least in its principles and objectives, as more as those planetary crises are advancing. So I think there is merit and boldness in the argument that the Inter-American Court made, and it's part of those efforts to really both center that understanding of humans and nature being one, and whenever they're seen as separate, really undermining the conditions for our very own existence and flourishing on this planet.
Thank you, Elisa. So we are running 15 minutes late, which means I'm a complete failure as a chair, but I do want to give you a few minutes, Philippe, to really close this discussion with some more inspiring, powerful statements. In response to what has been raised.
I think we've wrapped up, but I can't resist answering a question from someone called Eusebio, because I'm of the generation who remembers an incredible footballer who played for Portugal, who I loved as a kid. I still remember him in the 1966 World Cup, and he was fantastic. But I mean, the just transition question is a really important question, and you've asked a very practical issue. You go there and you negotiate. Who do you talk with, and what do you talk about, and what are the positions you're pushing for? And the law, I think, what's emerged from this conversation is the law provides a framework, and it's not itself going to provide the solutions or the answer to your question. It gives you a steer in terms of what can be done, what should be done, what shouldn't be done. And within that framework, ultimately, it will be other societal features that come in. And basically, just transition is going to be, the hard edges of intellectual property laws, technologies, and money. And for the next 3.5 years at least, you as a negotiator are going to face a very simple reality. There is one country out there that has turned its back on this. I can't imagine, the president of your country sitting down with the president of that country and having a conversation about just transition and moving away from fossil fuels, and will you support us, and will you provide us some more USAID, because it's not going to happen. So the reality of your situation is that one hugely important block has just taken itself off the table. And so what does that mean? What that means is you turn elsewhere, and you'll turn for technology and IP rights and money to those who have it, which is basically two blocks. It's the Europeans and it's the Chinese. And essentially what has happened in broader geopolitical terms, is extraordinary because the United States has essentially just opened the door to China, which is developing the technologies, which has the finance, which comes, I don't know about your country, but many countries in Africa that I'm working with have an incredibly close relationship now with China, including on these issues. A country which plainly is seriously committed to a transition and appears to be seriously committed to working with other countries around the world, as I think the Europeans are, although the Europeans don't quite have as much economic largesse and are apparently less generous with their technology transfers than that particular country. So in a geopolitical world for the next 3.5 years at least, that's a significant reality in terms of where a country like your country goes. And there's nothing that an advisory opinion of the International Court of Justice or even a judgment of the International Court of Justice in relation to that country, at least for the next 3.5 years, that is going to make any difference whatsoever in terms of how you shift in the direction you evidently want to shift into. So I think it's just a conclusion to say the advisory opinion is hugely significant. It will have responsibilities for national court, implications for national courts. It will have implications before international courts. It will have implications for corporations. It will have implications for each of you in this room. But it's always going to be coupled with other political, commercial, and social considerations that are going to determine what is the direction to be taken. And I think that's what makes the next period, in a sense, so incredibly interesting, but also one for which your generation is going to be really engaged and really actively involved. And I know, we have 3 children who are in their 20s and 30, and so this is a really big issue for them. I have the privilege of being involved, I think, in lots of things that I find interesting. The only time each of my 3 kids has ever written to me and said, sent a WhatsApp and said, "Oh, Dad, finally you're doing something useful," is in relation to ecocide and climate. And that says a lot to me about where we are going and the direction that ought to be taken and the faith my generation should be placing in your generation, because we have failed to deliver. We have left you a stinking heap of shit, frankly. And you are entitled to be rip-shit furious with us. We have left you a big mess. And we need to be honest about that. And we need to hear from you. And that's, in a sense, I think what is the most exciting thing about what happened about that advisory opinion. The judges listened. You said, I think you slipped slightly, but you said, we got more than we deserved. I don't think you meant that. I think you meant we got more than we could have ever hoped for. But that was a result of the work that you did and that community did. And I think that's, for me, incredibly exciting. 15 judges at the International Court of Justice drawn from around the world. I think they really listened to you. I think they really heard you. And I think that's a hopeful sign to end on.
I'm not sure if hopeful, but but thank you very much for that thought-provoking reality check, which I think is inviting us to continue this discussion with a bit of wine upstairs in the hub. Thank you very much, everyone, for coming tonight and with so much engagement with the panel. Before we leave upstairs, so the wine is 3rd floors up in the hub, there is a wine reception. Please join me in thanking our panelists with a big, well-deserved round of applause.